Court will be in session. Calling the first matter. This is Baxter County case CR 2019-2, State of Arkansas versus Robert Chapman. I'll review this case. It appears this case is on the trial schedule for the week of July 15th, and this hearing is a final hearing prior to that trial. We're getting ready to, or we're checking discovery. Is discovery complete?
Your Honor, it is completed. Visited with Mr. Chapman on Tuesday. Your Honor, this is a case that at this point appears to be headed for trial.
All right. I'll also indicate what I'm going to do is put it down for a final final appearance on July 11th. That'll simply to make sure everything's ready to go for trial. All right, Mr. Chapman, you may be excused.
What about the bond reduction Mr. Cooper was supposed to get?
You know, we did. He is correct. He has been in jail for a substantial period of time, and I think we have had one reduction of his bond already. But given the nature of the charges, given the fact that Mr. Chapman, where did you tell me that you would be living?
It'd be in Mountain Home.
How long have you lived in this area?
35 years.
And Mr. Chapman, the residence that you have described, is that a residence that you have lived out before you were arrested?
Yes, sir.
Would there be any felons or anyone else living in that household?
No, sir.
What says the state?
You know, the state had previously participated when this matter was reduced from a $10,000 bond to a $5,000 bond. We think a $5,000 bond is appropriate based on what he was charged with in this matter, Your Honor.
Your Honor, again, I point out to the court that this is not what I would consider to be a violent offense. The degree of felony is not a high degree of felony. There is always, as I usually at some point in a bond argument point out, a presumption of innocence for this gentleman. He has an address which he's given to the court. I think given the nature of the charge, the fact that he can reside in Mountain Home, that a bond of $1,500 to $2,500 would certainly be appropriate to secure his future appearances.
Mr. Cooper, who actually resides at that address that Mr. Chapman is providing?
Mr. Chapman,
Yes, sir.
would you inform the court who actually resides at the address that you just gave to the court?
That's Gary Beam. That's where I work at. I work for him when I'm not in jail.
Well, the state asked that question because we looking at tax records, both personal and real, it does not show Mr. Chapman owns any in Baxter County, Arkansas. Mr. Bean has an active case on our docket, Your Honor. And actually, it's on Judge Putnam's docket. Mr. Bean's case is.
You know,
So the state would object to him residing at an address with someone who's also charged with felony charges in Baxter County.
under my knowledge, Mr. Bean has not been convicted of any charge. If I could inquire of Mr. Chapman. Mr. Chapman, is there another address that you could live besides the address you just gave?
Yeah, I imagine.
Can you provide that now, or is that?
I'd have to call and verify it to make sure, but I could verify it to the bondsman or whatever if need to be before bonding.
You know, I think that
The court's inquiry is the residence the place where In the affidavit, it makes reference to a place where there were multiple motorcycles or four-wheelers. Is that the same place we're talking about where you resided?
No, sir.
You know, in talking to Mr. Etheridge, I believe that is no objection from the state to lowering the bond to $2,500, provided that Mr. Chapman can provide to my office another address and that we can verify to the court that it is okay for him to stay at that address.
Court is going to lower the bond to $2,500, cash or surety. That bond will be conditioned upon, obviously, no violation of the law, and it will also be conditioned upon not residing in or out of residence with charged or convicted felons. That will be the condition of the bond. So I'm assuming that means that this other address that he will locate and provide to the bondsman will be the place where it will be approved.
Mr. Chapman, can you call your bondsman and give that new address to your bondsman?
Yes, sir.
Okay.
All right.
Your pre-order had also stated he would have no contact with the victims.
No contact with the victim, which was a condition of the original bond. Yes. All right. You may be excused, sir.
Thank you.
(2019-46) State of Arkansas versus Andrew Lampkin. I don't find, Mr. Lampkin, if you made any arrangements to have an attorney represent you,
Yes.
what did you do?
Oh, declined the attorney. Plea of my
What
own.
arrangements have you made?
None. I haven't made any.
All right. Well, then I need to inform you that I'm reviewing this record. It does not show that the public defender's been appointed for you, and my inquiry now is, have you retained private counsel? Have you hired a lawyer?
No.
Okay. Have you made application for the public defender's office?
No.
Well, the court's going to advise you that you're entitled to be represented by an attorney. That's a constitutional right that you have. But you need to take some action to get it done. It doesn't happen automatically. So what I'm telling you is the right to an attorney gives you the right to go out and hire the attorney of your choice. And if you decide to hire private counsel, that's a matter of private contract between you and the attorney, and the court does not get involved in that. So that's what your right is. However, if you determine that you can't afford to hire an attorney, then you would be entitled to court-appointed attorney. But you need to inform the court that you want to seek a court-appointed attorney by filling out an application. Those applications are available there at the jail, and you need to get one from the jailer, fill it out, sign it, turn it in, and it will get to the public defender's office, and that appointment will be made.
Okay. Is there a way I can find about bond?
Well, at this point, your case is, I'm looking,
He's on a no bond hold out of Marion.
that's what I'd seen here before. There's no bond hold for revocation petition to be filed today. Was that out of Marion County that was filed?
Yeah.
Otherwise, the bond had previously been set at $5,000, but as I understand it, you are being held on a no bond hold on a petition to revoke out of Marion County. That's your status at this point.
Right.
All right? You may be excused. Your case is set for trial the week of August 19th, and we don't, at this point, we don't have any other dates for your appearance. I'm going to put you down I'm putting you down to reappear in front of this court on May 30th.
All right, cool.
You may be excused. Court will call 2019-144. This is the State of Arkansas versus Uriah Jones.
Your Honor, Mr. Jones is a recent appointee to our office. This is a case that Mr. Etheridge and I want to visit with you in chambers about at some point today. So there's no action to take right now with his case, Your Honor.
Mr. Jones is set here in Baxter County for trial during the week of September 16th. He's also set for a final hearing on August 1st. And the court, he was before the court yesterday via Skype in Baxter County, where he's got 2 or 3 sets of charges that have not been, the warrants haven't been returned, so we weren't able to make any progress at all. I think that problem is because he's in jail here and things haven't happened in Marion County, but we did it over the phone to get some of those cases set up so we could start moving forward on the Marion County cases, so he has substantial cases.
Your Honor, I think that Mr. Jones is looking somewhat confused because he was screened and accepted into Care Center, and rather than address that right now, it's something that Mr. Etheridge and I both need to talk about, but I do want to let him know that I'm aware that he has been seen and been accepted.
All right, so we need to arraign him today on these charges. We aren't going to get any arraignments done yesterday because the files haven't been set up. All right, Mr. Jones is charged with driving while intoxicated, misdemeanor, refusal to submit to a chemical test, driving on suspended license, reckless driving, all improper use of center lane, turn lanes, speeding, and then aggravated assault and fleeing. The latter two are both Class D felonies. On those charges, how does the defendant now plead?
Your Honor, he enters a plea of not guilty to all charges.
He is set down for trial during the week of September 16th. He is an August 1st reappearance date. The court, this is a case that I believe I indicated last time we were in court, that the court feels as though the originally bond that was recommended at $5,000 is totally inadequate. And the court, after I reviewed the facts of the case and the extent that he went, what he did in the way of fleeing in a vehicle at a high rates of speed, as indicated by the affidavit, the court feels that the bond should be more on the order of $25,000. So that's where I'm going to set it. Now, I will listen to and we'll review whether he's not he's appropriate for care ministries.
That is what we'd like to take up and show the court at a break, Your Honor.
All right. So that, for the record, the bond is being set at $25,000. Cash assured. You may be excused, sir. (2018-4) State of Arkansas versus Anthony Payne.
Your Honor, Mr. Payne, I think the only reason that he is in jail, and it's significant, is that there is a failure to appear. Mr. Etheridge and I have had discussion. There is no objection from the state that the failure to appear be recalled and that he reappear on May the 30th.
I have him down that he's set for jury trial the week of June 24th, and this was a review hearing date today. There's a bond forfeiture in this case, but was scheduled for hearing on show cause hearing in September 26th, but he's in jail now. After a series of continuances, this matter was a relatively old case in the sense that it was filed early in 2018, and they seem to be progressing all right, but there's been a series of continuances on this case. Is that because we couldn't get Labra back? Or?
It was,
No.
Your Honor,
That's,
and we have that.
And then on March 21st, it was continued for trial to the week of April 22nd, and he was ordered to reappear on April 18th, and that's when he failed to appear, was on April 18th. And the court issued an alias warrant. It's now that's where the show cause bond forfeiture hearing is set in September on that. And then we set the trial for the week of, we moved the trial to the week of June 24th, when we couldn't try him on the 22nd of April. That's where this matter stands at this point, is he's set for trial. And what is the request at this point?
the request from the defense is that the FTA be recalled. There is no further action that we would take today. We're not asking for any change in the scheduling order, but we'd like for the FTA to be recalled so he can be released from jail.
Your Honor, I show in the docket that the FTA warrant was served on April 24th, and he appeared before Judge Putman on April 25 to reappear here today.
So he's already been served with that warrant on failure to appear. And that's what's got him here today. I'm not particularly disposed, as old as this case is, as long as it's been continued, if we got it ready for trial and have a trial date, at this point, I'd like to hold him in jail.
Thank you, Your Honor.
We'll go to trial the week of June 24th. That's when it's set, because we missed the trial date in April because of his failure to
What if I've
appear.
bonded on this?
All right.
What if I've already bonded on this? How does that work? I'm
Well,
kind of confused on it all. I mean, the reason I
at this
missed is
point-
because,
At this point, I have to authorize you to be released on that bond, sir.
yes, sir.
And
The
I'm
reason
not
I
going,
missed
what I'm saying is I'm not going to do that.
Okay,
Now, this case is at least a year and a half old. It's not, and a lot of that is not your fault because of the time it takes from the crime lab to get their evaluation done. We had it ready for trial the week of April 22nd, but it got continued as a result of your failure to appear on April 18th. At this point, I'd like to see it go to trial on June 24th. I'm not going to release you at this point. So,
Your Honor, may I come back over and just change my plea then? And just get this over with?
We can bring him over this afternoon. He is one of the inmates that I did visit with on Tuesday, so he's well aware of his plea.
all right. I'll direct that the defendant will be brought over this afternoon. You may be excused for now. 19-20, State of Arkansas versus Mark Raymond Fiddler.
Your Honor, Mr. Fiddler is approaching with his wife, who is the victim. She is prepared to make a statement. I don't know if the court wants to have her make the statement now, or Mr. Etheridge, what's your,
Your Honor, the state has no objection to doing it now or doing it after lunch. It's whenever the court would like to take it up.
I'll be glad to take it up front now. Ma'am, go ahead.
Yes, sir, Mark and I have been married for about, well, we've been together for over 30 years. And since we moved to Arkansas, it just hasn't been easy. And we had just had a really big fight one night. And I don't know what happened. It just escalated. And, I've just never been through anything that horrific. And, he was going through a really bad time. And I was going through a really bad time. We was just moving here. And, we live out in the woods, Your Honor. We live up on a mountain, 7 miles away from our closest neighbor. And I came from Charleston, South Carolina. Your neighbor was like 2 feet away. I mean, I didn't like it here. And then he lost his job, and then we went broke, and his father went in the hospital. Too much just happened at one time. And I didn't know what was wrong with him, and he wouldn't talk to me. I didn't know what was going on because he wouldn't talk to me, and he was my only friend. He brought me here.
ma'am?
I would like to not
Do you
press
wish-
charges.
Are
No.
are you the victim in this case?
Yes, sir, because
And you are here today, do you wish to pursue charges against
No.
your husband, Mark
no, I
Fiddler?
love my husband. No, I do
And
not.
do you wish for him to receive probation?
You know, just drop everything. I just want to.
I understand.
No, I just want to go back to normal.
Are you in fear of your husband?
No. No, after 30 years, this is the first time, no.
Your Honor, it's the position of the state in this matter that the state have been asking for incarceration for Mr. Fiddler.
No.
Now, ma'am, you've had your say. Let Mr. Etheridge proceed.
You know, the state had been asking for incarceration in this matter. It was brought to my attention that the victim, Mrs. Fiddler, did not wish that to occur. It's the position of the state of Arkansas in this regard that the state will reluctantly agree to a probation plea. We believe that Mr. Fiddler needs to be watched and tracked because there was methamphetamine involved in this situation. We want to make sure that does not occur again. If the state is going to move towards a probation plea based upon Mrs. Fiddler's statement, we still believe there's a need to protect Mrs. Fiddler in the future and the state of Arkansas on this matter.
Thank you very much. All right, Ms. Fiddler, thank you for your statement, I appreciate it.
Thank you.
It will be considered as we go forward. Court will await the attorneys to present any pleas that are going to be presented.
Your Honor, Mr. Fiddler has the paperwork that Mr. Etheridge has just described, and if the court would recall that case after the break, then we'll have his plea ready today.
I'll call that case later.
Thank you, sir.
Maybe excused.